Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper reading. Today we will discuss the articles displayed on the screen from the Delhi edition of the Hindu newspaper dated 4th April 2019. So let's start our discussion. This article on page number 1 is related to a constitutional case which is going on in Supreme Court and is related to bringing the judiciary under the RTI. And it is especially related to bringing the proceedings of the collegium under the RTI scrutiny. So this will form a part of the General Studies paper 2 under the topic Governance and Polity. Now this issue of bringing the judiciary under the RTI scrutiny has been going on for a decade and various cases have been filed in the courts. So first we will look at the historical background of this issue. Further we will look at the questions which have been raised in front of the constitutional bench regarding the bringing of judiciary under the RTI scrutiny. And finally we will look at some of the previous instances where the Supreme Court itself has ruled that the RTI should be given primary importance. And at the end, we will summarize important points which emerge from these discussions. Now, first, let us look at the historical background of this issue of bringing the judiciary under the RTI scrutiny. So, regarding this, you should note that in the last decade, many applications or RTI applications have been filed by various citizens which have been seeking information from the courts and especially Supreme Court and High Courts. However, many of these RTI applications have not been entertained by courts. One such example is the RTI which has been filed by Subhash Chandra Agarwal in the year 2009. And this RTI was seeking the correspondence between the Supreme Court Collegium and the Center on the appointment of various judges in the Supreme Court. And the names of these judges have been given in this graphic. So regarding this RTI, the Supreme Court refused to provide this information. And this refusal by the Supreme Court in providing information which was asked under the RTI was challenged in front of the Central Information Commission. And this is the final authority or final appellate authority under the RTI Act. Now the Central Information Commission or the CIC also ruled in the favor of the RTI activist. And due to this decision by the CIC, Supreme Court appealed in the Delhi High Court against the CIC verdict. However, the Delhi High Court dismissed this appeal. Further, in the year 2010, a 3-judge bench of the Delhi High Court upheld the previous decision of the High Court which had dismissed the appeal of Supreme Court. However, in November 2010, the Supreme Court brought this case in front of itself. And finally, this case was referred to the Constitutional Bench in 2016. And in this constitutional case, various cases where the RTI activists had demanded information from the Supreme Court have been clubbed together. So let us take up these cases one by one. Now the first case was related to the appointment of the judges. And in this, an RTI applicant filed a request to the Supreme Court in 2009 seeking a copy of the complete correspondence along with file notings that were exchanged between the Chief Justice of India and other concerned constitutional authorities. So in short, this RTI application was seeking information related to the correspondence between the collegium and the government. And regarding this, as we have learned in the previous slide, the information was denied by the Supreme Court. However, the Chief Information Commission directed that this information should be provided. And this decision of the CIC was challenged by the Supreme Court in the High Court of Delhi. Now in this first case, which was regarding the information related to the proceedings of the collegium, the Supreme Court argued that it is not a public authority as has been defined under the RTI Act. So regarding the public authority which have been defined under the RTI Act and which fall under the RTI Act, the law states that the public authority means any authority or body or institution of self-government which has been established or constituted under the Constitution by any other law made by the Parliament, by any other law made by the state legislatures, and by notification issued or order made by the appropriate government. So according to this definition, we note that Supreme Court is a constitutional authority and that is why it should be under the scrutiny of RTI. And regarding those institutions which have been exempted under the RTI, for example the RAW, CRPF, CISF, etc., there is no clear exemption provided to the judiciary. So a natural conclusion is that judiciary is a public authority as defined under the RTI Act and it should fall under the scrutiny of RTI. Now regarding the second case which has been clubbed in front of the Constitutional Bench, you should note that Supreme Court in a resolution of 1997 required the judges to declare in front of CJI the assets held by them in their own name and in the name of their spouses or any person dependent on them. Now, in accordance with this resolution, an RTI application was filed and it required to provide information if any such declaration of assets was filed by the judges of the Supreme Court or High Courts to their respective Chief Justices. Now, this information was also denied. However, the Central Information Commissioner directed that the information which was sought by the applicant should be provided. However, again, this decision of the CIC was challenged by the Supreme Court in the Delhi High Court. And it was argued by the Supreme Court that the information which was asked by the RTI applicant fell under the personal information which has been provided for in the section 81J of the RTI Act. However, regarding that RTI application, the High Court ruled that the applicant had only sought to know whether the 1997 resolution was complied with or not. So due to this, the information which has been asked for should be provided. Further, the High Court ruled that the judge's assets does not qualify as personal information which has been exempted under the section 81J of the RTI Act. So the first case was related to the correspondence or the communication between the collegium and the government, and the second case was related to the declaration of assets by the judges of Supreme Court and High Courts in front of their Chief Justices. After this, let us look at the third case. Now, in the third case, an RTI application was filed with the Supreme Court, which was based on a media report and which had asked for copies of correspondence between the Chief Justice of India and a judge of Madras High Court. And this media report was regarding the attempt of a union minister to influence the judicial decisions of the said High Court or the Madras High Court. Now, the applicant had asked for information regarding the name of the minister who was trying to influence the decisions of the Madras High Court. Now, again, the Supreme Court denied this information to the applicant. However, it was challenged in front of the Central Information Commission. Now, again, the CIC had provided that this information should be provided to the applicant. However, this was again challenged in the Delhi High Court, and from there on it was challenged in the Supreme Court. So in all these three cases, the Supreme Court denied the information to the RTI applicants. Now all these cases have been clubbed together in a constitutional case and has been presented in front of a constitutional bench. So now let us look at what are the key constitutional issues or what are the key important issues which arise out of these cases. Now all these three cases have been clubbed together and have been referred to a constitutional bench. And the basic question in front of the constitutional bench is regarding the independence of judiciary and the fundamental constitutional right to citizens about the freedom of speech and expression. So the three questions which the constitutional bench is looking into are, the first is that whether the concept of independence of judiciary requires and demands the prohibition of furnishing of the information which is required by the RTI applicants, and whether this information which has been asked for amounts to interference in the functioning of judiciary. So this is one of the questions that is in front of the constitutional bench. And this is related to the first case, as we have learned, which requires the Supreme Court to provide information related to the proceedings of the collegium. And we note that the appointments in the judiciary in Supreme Court and High Courts is done on the basis of consultation with collegium. The second question in front of the constitutional bench is that whether the information which has been asked for by the applicant cannot be furnished to avoid any erosion in the credibility of the decisions and to ensure a free and frank expression of honest opinion by all the constitutional functionaries, and which is essential for the effective consultation and for taking the right decision. So this is also related to the functioning of collegium and also the issue which was raised by the RTI applicant regarding the communication of CJI and the Madras High Court. And the third question in front of the constitutional bench is related to the personal information which the RTI applicant had asked for regarding the asset declaration by the judges in front of Chief Justice of India. So the question is whether the information sought for is personal information and therefore should it be exempted under the section 81J of the RTI Act. So these are the three prominent questions which have been raised in front of constitutional bench regarding bringing the judiciary under the RTI scrutiny. Now the refusal of information by the Supreme Court in all these cases stands in contradiction with its own stand in other cases. For example, the Supreme Court in one of the cases in 2012 had stated that it cannot be doubted that the transparency is sine qua non for the restraint on abuse of judicial power. And transparency in decision making not only makes the judges and decision makers less prone to errors, but also makes them subject to broader scrutiny. So, in this case, the Supreme Court had contended that transparency is a must for the accountability of judiciary, and it also puts a restraint on the abuse of judicial powers. Further, it also improves the quality of decision making by the judges. In another case, which is known as the Union of India versus the Association for Democratic Rights, in 2002, the court had directed the Election Commission of India to provide for the information from all candidates which are seeking election to the parliament or state legislative assemblies. And this direction of the Supreme Court provided that the candidates should declare the assets of their spouses and their dependents also. So a similar case is now going on in Supreme Court regarding the assets declaration by the judges. However, in that case, the Supreme Court has denied the information. Further, in another case in Supreme Court, the applicant had asked that contesting candidates should not be required to disclose the assets and liabilities of their spouses, because this will infringe their right to privacy. However, the Supreme Court in that case also ruled that when there is a competition between the right to privacy of an individual and the right to information of the citizens, the former right has to be subordinated to the later right, as the later serves as a larger public interest. So in this case also, the Supreme Court had ruled that the citizens' right to information was very important for the democracy. And that is why the right to privacy of the spouses of the candidates which are seeking election to the parliament is secondary to the right of citizens to get the information regarding their assets. And that is important for the functioning of democracy. So in all these cases, the Supreme Court has ruled in the favor of citizens who are asking for information. However, in its own case, it is denying the information. So this has been seen by critics as a contradictory stand of the Supreme Court. So now this case is going on in front of a constitutional bench and it is yet to be decided. So it is a news in transition. However, let us look at the arguments which have been put up by the Attorney General, who is also the Public Information Officer of the Supreme Court. So in this regard, he has highlighted that opening up the highly sensitive correspondence of the Supreme Court's collegium and its working to the right to information regime would make the judges and the government shy and would also destroy the judicial independence. So he has argued that if the information related to the proceedings of the collegium are provided to the citizens under the RTI, it will destroy the judicial independence. Further, bringing the proceedings of the collegium under the RTI scrutiny will curb the free and frank discussions under the collegium, which means that it will also impact the freedom of expression of the judges who are participating in the collegium, and they will not be able to function independently once this information gets into the public domain. Further, he has argued that disclosure of highly sensitive communication under RTI will risk the very existence of the judicial way of functioning. So regarding the independent judicial way of functioning, Attorney General has argued that such highly sensitive communication should not be provided under the RTI. And regarding the disclosure of the personal assets of the judges under the RTI, the Attorney General has argued in front of the Constitutional Bench that it amounts to unwarranted intrusion into their privacy. So regarding this, he has argued that it will impact their right to privacy. However, as we know that in a previous case, the Supreme Court itself had ruled that the right to privacy comes secondary to the freedom of expression which has been provided to the citizens under the right to information. So now let us summarize all the points that we have discussed here. So first is that the information which has been denied by Supreme Court is related to the proceedings of the collegium and the communication with the government regarding the appointments of judges. Secondly, it has also denied information regarding the disclosure of personal assets of the judges. And thirdly, it has denied the information related to disclosure of the name of a union minister who is supposedly influencing the decisions of Madras High Court. Now, why has the Supreme Court not provided this information? This is because it impacts the independence of the judiciary, and the disclosure of assets or personal assets of the judges amounts to intrusion in the right to privacy of the judges, and which is also important for the independent functioning of judiciary. However, why this information should be provided. Now in this line you should note that the right to information should be given primacy in the larger public interest. Secondly, transparency will increase judicial accountability and will improve the judicial decision making. This is because all the decisions of judiciary will now be subjected to public scrutiny. Thirdly, in various judgments, the Supreme Court itself has ruled in favor of RTI against the secrecy. And for example, in one of the cases, the Supreme Court itself has ruled that the assets of the candidates and their spouses and children should be declared who are seeking elections to the Lok Sabha. And this should be done in order to enrich the democracy. So these are few points which emerge out of our discussion. So after going through this discussion, you can try and answer this question from your mains examination point of view. Now this news is in transition and let us wait for the story to unfold further and the decision of the Constitutional Bench regarding bringing the judiciary under the RTI scrutiny. And with this, let's move to the next article. Now this article on page number 9 deals with using behavioral science in the design of cash transfers and which can make them more effective in fighting against the poverty. And previously in the mains examination, various questions have been asked regarding the issues with the implementation of poverty eradication schemes by the government. For example, in the year 2018, this was the question, and in the year 2017 also, there was a question regarding the problems or issues with the poverty alleviation programs. So in this regard, you should note that recently, the Indian National Congress has announced a Yojana which is known as the Nyunatam Aay Yojana. And this scheme aims at giving rupees 6,000 every month to the bottom 20% of the population. Similarly, the current government has announced the PM Kisan Yojana, which is also a direct cash transfer scheme. So in this regard, various economists have raised concern regarding these cash transfer schemes like the PM Kisan Yojana and the Nyunatam Aay Yojana. However, this article highlights that all the concerns which have been raised by the economists against such cash transfer schemes are unfounded. So let us look at both these arguments. Now first let us look at the concerns which have been raised by economists against the direct cash transfer schemes like Nyay and the PM Kisan Yojana. So the first concern is that there will be withdrawal of beneficiaries of these schemes from the labor force, and this can lead to a labor crunch in the market, and which is not being seen as a good sign for labor intensive industries. And this is also likely to adversely impact the agricultural sector where the majority of labor force is employed. Secondly, the money which is transferred to these beneficiaries can be misused, and they can lead to temptations for sin goods like the alcohol, tobacco and gambling. And also, there is lack of evidence of poverty alleviation by such cash transfer schemes. So these are three general concerns which have been raised by various economists regarding the direct cash transfer schemes. Now, opposed to the concerns which have been raised by economists against the unconditional cash transfer schemes, this article highlights evidences which have been incorporated in the pilot universal basic income programs in Kenya and Tanzania. And accordingly, this article concludes that such direct cash transfer schemes will have transformative effect on the poverty alleviation if it takes into account these empirical evidences. So first empirical evidence that has come out of the UBI study in Kenya and Tanzania is that rather than spending the money on temptation goods like alcohol and tobacco, the people tend to invest the money in more productive assets which enable them to take up entrepreneurship or more productive employment. And this leads to increase in household consumption, improvement in health and education outcomes. It also leads to women empowerment when the amount is paid to women. So as against the concerns which was raised by several people that it will lead to consumption of various temptation goods like alcohol, tobacco and gambling, the evidence which has been found from Kenya and Tanzania is opposite. Because people have been investing such money in more productive assets and this has enabled them to take up entrepreneurship and more productive employment. And as a result, there has been improvement in the health and education outcomes and also led to the women empowerment when this money was being paid to the women. Secondly, the studies have also concluded that there is no adverse impact on the willingness of the people to work. So in this regard, the studies have highlighted that most of the time, the poor people are mentally burdened due to their lack of ability to meet their food needs or basic needs. And because of this, their mind is preoccupied with meeting their immediate needs rather than thinking about learning new skills or taking up more productive employment. And as such unconditional cash transfers are an assurance of minimum income, and this leads to psychological and mental unburdening, which in turn improves their decision making ability. Which means that rather than focusing on fulfilling their basic needs or food needs, such people can now focus on other capabilities. And these other capabilities can include learning of new skills or search for more productive work. So, in short, if implemented properly, such unconditional cash transfer schemes will lead to psychological and mental unburdening of those people who have now only been focusing on the fulfillment of their basic needs. Further, various behavioral economists have argued that cash transfers could bring about behavioral and attitudinal change in the mindset of people. For example, labeling a cash transfer as an education transfer can help in improvement in the school participation. Similarly, the promise of cash transfer forces the people to make future plans for productive uses of such money. So, such behavioral and attitudinal changes in the mindset of people can be brought about if they are assured of a minimum income. Now, to understand the importance of unconditional cash transfers, you can go through the Universal Basic Income chapter of the Economic Survey of the year 2016. And it has highlighted both the study of Kenya and Tanzania, and also it has highlighted various benefits and the philosophical foundations of the Universal Basic Income. So, regarding the conceptual and philosophical case for Universal Basic Income, the survey highlights that the Universal Basic Income promotes social justice. And in this case, it has been argued that a universal basic income promotes the many basic values of the society, which respects all the individuals as free and equal. Further, it promotes liberty because it is anti-paternalistic and opens up the possibility of flexibility in the labor markets. So it is similar to the argument as we have learned that it will psychologically and mentally unburden the poor, and now they can focus on more productive jobs like skill development, etc. Further, the universal basic income also promotes equality by reducing the poverty, and it promotes efficiency by reducing the waste in the government transfers. So presently, as we know that there are various leakages in the implementation of various poverty alleviation schemes. So such leakages can be reduced, and this will reduce the wastage in the government transfers. Further, the universal basic income can be an important tool for poverty reduction in India. However, this is conditional on the presence of a well-functioning financial system. Further, the survey argues that the present era is being seen as an uncertain employment generation era. And in such an uncertain employment generation era, the universal basic income can guarantee a minimum living standard to the people. Further, regarding the administrative efficiency, the survey states that the existing welfare schemes in India have been riddled with misallocation, leakages, and exclusion of the poor. However, the survey highlights that if the Jan Dhan Aadhaar Mobile Trinity or the JAM number Trinity is fully adopted, administrative efficiency can be brought about in such unconditional cash transfer schemes or the universal basic incomes. Now, without getting into the details, let us look at some of the arguments in favor of universal basic income which has been provided by this chapter. So first is that it will lead to poverty and vulnerability reduction. Secondly, it will lead to better targeting of poor. Thirdly, it will act as an insurance against shocks. And as we know that poor are adversely impacted in cases of monsoon failures, etc. So this will act as a safety net against the shocks like monsoon failure or health or income shocks. Further, such kind of schemes will lead to improvement in the financial inclusion. This is because such unconditional cash transfers or the universal basic income will act as an incentive for the population to get into the financial net. And as we have learned, this will also lead to psychological benefits and also administrative efficiency. Further, as we have learned in this article, the study was conducted regarding an unconditional cash transfer program in Kenya. And it found that there is a significant increase in the psychological well-being of the recipients, which was measured in terms of happiness and life satisfaction and the reduction of stress. So for more details, you can go through this chapter of the Economic Survey of 2016, which is available online. Now, after going through this discussion, you can try and answer this question from your mains examination point of view. And you can use various points which have been highlighted in this discussion, as well as the points which have been mentioned in the Economic Survey of 2016. And with this, let's move to the next article. Now, this article on page number 9 has been written by a former chief of the CBI. And this article is related to the Lokpal, which has recently been appointed. And in this article, the author has highlighted the issue of overlapping jurisdiction of various anti-corruption bodies like the CBI, the Central Vigilance Commission, and the Lokpal. So this shall fall under the General Studies paper 2 under the topic Polity. Now, various aspects of the Lokpal like the powers and duties have been discussed in the DNS of 24th March 2019 in detail. So in this article, we will only highlight the various jurisdictional issues which have been highlighted by the author. For the basics of Lokpal, its powers and duties, you can go through this Daily News Simplified of 24th March 2019. Now, the first issue of overlapping jurisdiction of Lokpal and CBI is related to the corruption cases. And in this regard, you should note that regarding corruption cases, the Lokpal has jurisdictions over the Group A and Group B of the public servants. Now, here it should be noted that besides Lokpal, the CBI also has its own jurisdiction over these two public servant groups. Further, the Lokpal has also been empowered in using the CBI as a prosecution wing for examining a complaint against a public servant for misconduct. Now, this power of Lokpal is overlapping with its own inquiry wing. So here it should be noted that a complaint in front of Lokpal can either be examined by its own inquiry wing, and also the Lokpal can permit the CBI in examining a complaint regarding public servant misconduct. So this means that there is overlapping jurisdiction between the inquiry wing of Lokpal as well as the CBI. Further, it should be noted that although the Lokpal has its own inquiry wing, it can also forward a complaint to the CBI for a preliminary inquiry. And after this preliminary inquiry is over, a case can be lodged under the Prevention of Corruption Act 1988 as a regular case. So these are the powers which have been provided to Lokpal, and also there are powers which have been provided to CBI. Now these two are overlapping. So let us look at the issues which will come up because of these powers. Now, regarding the corruption cases, you should note that the Lokpal can order the CBI to conduct a preliminary inquiry. Further, you should note that besides Lokpal, the government can also order a preliminary inquiry and permit the CBI to proceed with a regular case. Now, besides the Lokpal and the government, even the CBI on its own can register a case against the public servant if he is caught red-handed while receiving a bribe. So here it should be noted that the Lokpal, the government and the CBI all have been provided with the powers of conducting a preliminary inquiry in cases of corruption. So in this regard, the author has highlighted that in India, there is a common practice of filing corruption cases in front of multiple bodies. So in case an individual lodges complaint against the government and the Lokpal, what will the Lokpal do in such a case? Now in such a scenario, what will the Lokpal authority do? So this is a question which has been raised by the author. Now as we know that the Lokpal's inquiry wing also has the power to conduct the preliminary inquiry, and in case if the complaint has already been forwarded to the CBI by the government and it is also conducting an inquiry, can the Lokpal give directions to the CBI to pause its proceedings and wait for the Lokpal's own inquiry wing to handle the matter? So this can be a conflicting issue in the jurisdiction of both the Lokpal and the government regarding the prosecution of corruption cases. Now, another issue which the author has raised is regarding the superintendence of the CBI. So in this regard, the author says that the government has greater power of superintendence over the CBI as compared to the Lokpal. Now, this can be a potential prospect of clash between the government and Lokpal. This is because the government has greater powers of superintendence over the CBI. Now, although according to the Lokpal Act, it looks as if the superintendency or the supervision of CBI is shared by both the Lokpal and government, this can lead to potential conflicts in the coming future. Now, as both the government and the Lokpal have supervision powers over the CBI, can the Lokpal order the CBI to suspend any inquiry in respect of a complaint and report to Lokpal without letting the government to interfere? And this will not be taken positively by the government because the government already has greater powers of control or supervision over the CBI. So in short, the author has highlighted that there will be jurisdictional issues with regard to supervision of CBI and also with regard to inquiry which is conducted under the corruption cases because the government and the Lokpal and also CBI in some cases has got the power of conducting this inquiry. Now, as the Lokpal has recently been appointed, so let us wait for it to function and let us wait for such issues to come up. So this is a news in transition, and in this line you should only learn about the point which has been raised by the author. So with this, let's move to the next article. Now this article on page number 7 is related to the State of Global Air Report 2019. And this report highlights that the air pollution is shortening the lifespan by 30 months. Further, the study has claimed that poor air quality caused about 1.2 million deaths each in India and in China in the year 2017. And the major life hazards which are posing a risk to the loss of life expectancy include the dietary risks, cancer, tobacco, and air pollution. Further, the report has highlighted that the air pollution exposure reduces life expectancy by 20 months on an average worldwide. So as you can see by this graphic that the air pollution has become the fourth largest killer after dietary risks, cancer and tobacco. Now what is important for us from the preliminary examination point of view is the organization which releases and compiles this State of Global Air Report. So in this regard, you should note that this report is compiled by a United States based Health Effects Institute and the Institute of Health Metrics and Evaluation, which is also based in US. And both these institutes work in collaboration with expert input from University of British Columbia. So from preliminary examination point of view, only the bodies which release the State of Global Air Report are important for us. And with this, let's move to the next article. Now, besides the 4 articles that we have discussed, there are 2 other important articles in today's newspaper. However, both these articles have been discussed previously in the DNS videos. For example, this editorial on page number 8 is related to the quashing of February 12th circular by the Supreme Court. And regarding this, you should note that it has been discussed in detail in the DNS of 3rd April 2019. So you should go through the Daily News Simplified of 3rd April 2019 in order to understand the details of the February 12th circular and also why has the Supreme Court strike down this provision or this circular of the RBI. Further on page number 13, there is a news article which reads, why a rate cut won't help lower lending rates. Now this is related to the monetary policy transmission and the impact of external benchmarking. And this has been discussed in the DNS of 29th March 2019. So to understand the basics of monetary policy transmission and the external benchmarking, you should go through the DNS of 29th March 2019. Now after this, let us take up practice questions from our preliminary examination point of view. Now after going through today's discussion, you should try and answer these questions from your preliminary examination point of view. The answer for these questions will be displayed after 5 seconds. So the first question reads, consider the following statements about the Right to Information Act. The first statement reads, emails are not considered as information under the RTI Act. Now this statement is incorrect because any government communication can be considered under the RTI Act. And accordingly, email is also a form of communication or information which has been covered under the RTI Act. Secondly, the NGOs are not considered as public authority under the RTI Act. Now, as we have learned in today's discussion about the public authority, you should note that any body which has been substantially funded by the central government can be brought under the RTI Act. And accordingly, any NGO which has been substantially funded by the government can also become a public authority under the RTI Act. That is why this statement is also incorrect. So the correct answer is D, that is neither 1 nor the statement 2 are correct. The second question reads, consider the following about the Lokpal Act. The first statement reads, only a judge of the Supreme Court can become the chairperson of the Lokpal. Now this statement is incorrect because besides the judges of Supreme Court, any eminent person can become the chairperson of the Lokpal. Further, the second statement reads, a judge of a high court can become a judicial member of the Lokpal. So here it should be noted that this statement is incorrect because the Lokpal Act provides that judges of Supreme Court and only the Chief Justice of High Court can become a judicial member of the Lokpal. That is why here also the correct answer is D, that is neither the statement 1 and 2 are correct.
Further, you should try both these questions from your preliminary examination point of view, and the answer for these questions will also be displayed after 5 seconds. So the first question reads, consider the following statements about the state of global air report. The first statement reads, it is published by WHO. Now this statement is incorrect as we have discussed in today's article. The second statement reads, it deals with gases responsible for global warming. Now this statement is also incorrect because it deals with the health impact of the pollution. So here also the correct answer is D, that is neither the statement 1 nor the statement 2 is correct. The fourth question reads, consider the following statements about the CVC or the Central Vigilance Commission. The first statement reads, CVC is a statutory body. So here it should be noted that CVC was constituted in the year 1964. However, it was accorded the statutory body status in the year 2003. The second statement reads, CVC can have maximum 3 members. Now this statement is also correct. So the correct answer that comes out is C, that is both the statement 1 and 2 are correct. Now in continuation of our series regarding the important aspects of the prelims compass, today we will take up the prelims compass of environment and ecology. Now let us understand how this prelims compass will help you in preliminary examination. Now if you go through the previous year examination papers of the preliminary examination, you will find that in environment and ecology section, questions have been asked based on these important themes. For example, international initiatives, national initiatives, important species in news, chemicals or pollutants, theory and basics, and national parks and Ramsar sites. Now, for example, in the year 2018, there was a question related to momentum for change under the international initiatives. Further, if you go through the national initiatives, you'll find that there was a question regarding the comparison of National Green Tribunal versus the Central Pollution Control Board. Now regarding important species, you should note that there was a question in 2018 related to an invasive species known as Prosopis juliflora. Further, regarding the national parks or Ramsar sites or biodiversity hotspots and the biosphere reserves, you should note that in the year 2018 there was a question related to Pakhui Wildlife Sanctuary. And regarding theory, you should note that in the year 2018 there was a question regarding the carbon fertilization. So as you can see, mainly the questions in the environment ecology section are asked from these important themes. And accordingly, the prelims compass for environment and ecology has been designed in such a manner to cover all these aspects comprehensively. So first of all, it provides you with core knowledge or the theory. And it includes important concepts like ecology, biome, what is ecotone, ecological pyramids, etc. Further, this also includes important international initiatives like the Cartagena Protocol, the Nagoya Protocol, the Aichi biodiversity targets, etc. Besides important international initiatives, you should note that it also includes various aspects of national initiatives like the Wildlife Protection Act 1972, what are the vermin animals which have been declared under this Wildlife Protection Act, about the Wildlife Institute of India, etc. Further, it provides you with a comprehensive list of the national parks, and these national parks have been provided in a state-wise manner. And as we have learned previously, questions have been asked in the preliminary examination for matching the national parks with the state in which they are located. And it also throws light on the Indian Forest Act, Forest Survey of India, etc. Now, apart from the national parks, it also provides important biological or biodiversity heritage sites and also the list of biosphere reserves in India. Now, this list of biosphere reserves in India also provide details about the location of these reserves, the important flora and fauna of these reserves, and the important tribal communities that are located within these biosphere reserves. After this, the important biodiversity hotspots that are present in India have also been discussed. And this can be a very important aspect for us from the preliminary examination point of view. Further, the prelims compass also provides an exhaustive list of the Ramsar wetland sites that are present in India. And also important flora and fauna which has been in news. For example, it provides information related to Neela Kurunji plants which have been in news. Further, it talks about important policy initiatives relating to the conservation of biodiversity and forests, and national initiatives like the National Biodiversity Authority and Biodiversity Conservation and Rural Livelihood Improvement Project, etc. Further, we note that under environment and ecology, the conservation of tigers is also one of the important aspects. So accordingly, for conservation of tigers, what are the important initiatives that have been included in this magazine? And also it provides an exhaustive list of the tiger reserves that are found in India and regarding their locations. And besides the tiger conservation, it also highlights the conservation of elephants. Further, we have learned that the pollution and climate change is another important aspect for us from preliminary examination point of view. And in this line, it highlights important initiative related to climate change, and for example, it throws light on the tropospheric ozone or the ground level ozone, etc. and important pollutants which are released by important industries. And also it talks about international treaties and organizations. After the treaties and organization, it also talks about national organizations, schemes and policies and programs. Further, if you go through the previous year papers, you will find questions related to energy conservation in India. And you should note that the Bureau of Energy Efficiency and its initiatives have been in news and have been asked in the preliminary examination. So accordingly, this aspect has also been covered comprehensively. And the final section deals with geography, disaster management and miscellaneous important topics, for example, the riptides, etc., which have been in news. And at the end of Prelims Compass, you will find practice MCQs and the answers for those questions. So as we have learned, the Prelims Compass comprehensively covers various aspects of environment and ecology from our preliminary examination syllabus. And you can find a link to this magazine in the description of today's video. Now let's move on to the question for the day. With this, we have come to the end of today's discussion. Now let's move on to the question for the day.